Justice Oak, members on the dais, and members in the audience. Thank you all for attending today's function in such large numbers when we felicitate Justice Oak on completing such a long innings and retiring as a judge of the Hon'ble Supreme Court of India. Your presence here highlights the deep respect and regard that all members of the bar have for Justice Oak. Now, the first thing that comes to mind when one talks about Justice Oak is his work ethic. It is unparalleled, and we have been privileged to have experienced it firsthand in the Bombay High Court. I personally recount when Justice Oak was with us in the Bombay High Court, he would travel from his house in Thana, and he would often use the P. DeMello Road. And his car would pass my car, and whenever I glanced and tried to look inside, I would see Justice Oak's head always with papers in his hand and always reading some matter which I'm sure would be in court on that day when he was on his way to court. That was his work ethic. Now let me not take up much more of your time and instead call upon our President, Mr. Thakkar, to address the gathering. Mr. Thakkar.
Justice Abhay Oka, former Judge of Supreme Court of India, Mr. Venkatesh Don, Vice President, Mr. Farhan Dubash, Secretary, all senior advocates, members of the bar, ladies and gentlemen. A very good evening. Mahatma Gandhi once said, there is a higher court than courts of justice, and that is a court of conscience. It supersedes all other courts. This statement rings true with various judges across Indian history. And today, we are honoring one such judge whose decisions were rooted in his conscience, none other than one of our own, Justice Abhay Oka. His thoughtful and principled jurisprudence, always in service of life, liberty, and the rule of law, marked a distinguished second innings that concluded just 4 weeks ago. Let me share with members of the bar an incident that happened in the court of former Chief Justice on 17th and 18th of July 2006. Last 2 days of the tenure of the Chief Justice with whom Justice Oka was sharing the bench. A PIL in which there was an interim order, it had environmental and urban development issues, was urgently moved for being placed for final hearing. No court would do a final hearing matter in last 2 working days of the tenure of one of the judges. But the Chief Justice placed on board the matter for final hearing. After disposal of urgent matters on board, Justice Oka rose citing ill health, and the bench rose with him. Even after the recess, the bench did not assemble. Next day was the last day of the Chief Justice. Still, the matter appeared on the board for final hearing. Again, the same thing was repeated. After the urgent matters were over, Justice Oka rose citing ill health. We at the bar were convinced that Justice Oka was a conscientious judge who would not allow any case, however important, be rushed through in a manner that would tarnish the image of a fair and independent judiciary. The bar noticed, appreciated, and applauded the spark in the judge, because it was in only 2003 that Justice Oka first came to the High Court as a judge, and when this happened, judge had only completed 3 years on the bench. For 16 long years, Justice Oka dispensed justice in Bombay High Court without fear. By name you are Abhay, that is fearless. Commuting daily from Thane with loads of paper books, as was mentioned by Farhan just now, that you read both en route and on return. That was exemplary grit and determination. We can always set our watches to 11 a.m. when you would take seat on the bench. I remember once you had a matter in chambers at 2:30 p.m. with another judge, and that got extended beyond 3 p.m. And when court resumed after recess, you apologized for the delay. Every day you took up the production board at 4:45 and revealed that you had used the recess to study the briefs. That combination of preparation and courtesy became your signature. Personally, I will never forget 20th November 16, not because on that day we celebrated our 150 years, but for what you told me in the foyer of Jamshed Baba Auditorium. The Bombay Bar Association had conducted the function with grace and dignity, without corporate sponsors. I shared your reaction with Dr. Sathe and Dr. Saraf, and we got satisfaction that you endorsed the actions of Bombay Bar Association. Thank you, Justice Oka. Your judgments have not only upheld fundamental rights, but also extended them. Your thoughtful jurisprudence truly embodies the notion that the Constitution is a living document. While at Bombay High Court, you secured citizens' right to worship and the right to choose not to worship. Further, you ensured that a person has the freedom to consume food of their own choice as a part of their right to life and personal liberty under Article 21. Your Lordship's judgment on pollution of the river Godavari and on noise pollution in the state shows a level of foresight and care for future generations. Justice Oka, you have been a stalwart of judiciary. Your conduct and unwavering commitment to justice left such an impression that 8 years ago, while hearing noise pollution matters, when blatant executive overreach and judicial independence came to clash, the Bombay Bar Association, along with all others, stood behind you. And let me share with you that on that day, there were 504 members present, as per our attendance book, who unanimously voted for the resolution. That is probably highest attendance for an EOGM. There was hardly any space to stand, and we did so not merely because of our duty as members of the bar to uphold independence of judiciary, but because of our faith in you as a judge. It takes a judge of rare dedication and integrity to gain such universal respect. Your Lordship's endeavors during one of the most difficult times of our country that faced a COVID-19 pandemic, you played a very important role as a Chief Justice of Karnataka High Court. You saved lives by thinking of prisoners, workers, children, migrants, and other vulnerable groups by taking up an active stance. Amid these challenges, you stood as a voice of both reason and reform. I fondly remember earlier this year, you had graced Ashok Desai Memorial Lecture and had shed light on the harsh realities of judicial infrastructure, particularly in Maharashtra, where you spoke of how civil judges in Pune had no chambers and how securing basic facilities from the government was a long struggle. In speaking these truths to power, you gave voice to what many experienced but few dared to articulate. You noted the role of the judiciary in ensuring that in at least 15 district courts, which were built fresh in 5 years since the court's orders through public interest litigations. Your contribution for getting plot at BKC for High Court building will forever be remembered with reverence. That act alone reflects your quiet determination to improve the judiciary's future. When you raise concerns over magistrates overwhelmed by check bouncing cases or citizens struggling to even get FIRs registered, it was evident your jurisprudence is grounded in the live experience of common Indian citizen. Your insistence on fairness, even for those accused of the gravest crimes, is a reminder of what constitutional fidelity truly means. You have never shied away from hard debates, whether it is on the death penalty, media trials, or the quiet erosion of civil liberties. In every word, every judgment, every public address, you compel us to introspect, to reform, and to recommit ourselves to the ideals we profess to uphold. And then there is the legacy you leave behind in the Supreme Court of India defined by constitutional clarity and moral courage. Your judgments consistently reinforced the fundamental principles that liberty is not a privilege to be rationed, but a right to be protected. Even and especially when the law becomes harsh. In Jalaluddin Khan, you reminded us that bail is not a concession, but a rule, reaffirming that this principle does not vanish simply because the UAPA is invoked. And in Thwaha Fazal, you went further, granting bail to a student accused under the same statute and holding that mere ideological leanings or loose associations are not enough to justify incarceration. You reminded us that when the government disregards due process, the courts must not look away. In your hands, Article 21 was not an abstraction, it was a shield. Your criminal law jurisprudence is anchored in the principle that fairness must never be sacrificed at the altar of convenience. In Nagendra Saha, you held that where evidence is shaky, where the chain is broken, the presumption of innocence must prevail. You refuse to allow suspicion to replace proof. But your fidelity to constitutional values extended beyond liberty. It embraced the environment itself. In Vanashakti, you struck down a policy that sought development without environmental clearance, asking pointedly, can there be development at the cost of the environment? You reminded us that Article 21 protects not only life of individual, but the life of the land itself. Across every domain, criminal, environmental, constitutional, your judgments reflect a consistent judicial philosophy that constitutional integrity is not negotiable, even when it is inconvenient, unpopular, or politically sensitive. Your legacy in the Supreme Court is not defined merely by your tenure, but by your tenacity. A tenacity in defending due process, tenacity in holding power to account, tenacity in reminding us that the Constitution is not a document of convenience, but a covenant of justice. In every ruling, you compelled us to remember what the court was meant to be, a place where the individual, the voiceless, and the vulnerable could still find strength, not in numbers, but in principle. You made the Constitution audible again. Since retiring on 28th May 25, you have already announced that you are not going to accept any position in government appointed institutions, beginning a third innings marked once again by independence. We, the members of Bar Association, salute you for your glorious career as a judge and wish you a very happy, healthy and busy third innings. Thank you.
May I now ask our President, Mr. Thakkar, to present a plant to Justice Oak. And our Vice President, Mr. Dhond, to present a small memento to Justice Oak. May I now call upon Justice Oak to address the audience.
Good evening, Mr. Nitin Thakkar, President of the Bombay Bar Association, Mr. Venkatesh Dhond, Vice President, Farhan Dubash, Secretary, other office bearers, senior members of the bar, junior members of the bar, and especially junior members who are here in large numbers, ladies and gentlemen. It's my third felicitation by BBA. First was way back in August 2003 when I was appointed as judge of the Bombay High Court. Second one was on the last working day before summer vacation of 2019. It was 3rd May 2019 at 10 o'clock. And I was astonished to see similar crowd on that day also. And today is the third one. Now my fairly long journey of 21 years, 8 months and 25 days is over. And therefore now time has come for me to express gratitude to the members of this bar. Mr. Thakkar referred to something which happened in July 2006. 2 years back, there was a regional conference of National Judicial Academy in Chennai, which was attended by several judges of the various high courts and district courts. Eminent member of this bar who now practices in the Supreme Court said publicly that someday I should come very clean about what exactly happened in 2006. Those who heard ceremonial hearing, again, a senior member of the bar who is from Bombay repeated that. And I can say that what Mr. Thakkar said is only 10% of it. But those who have heard me saying in SCBA function that for 3 months, I don't want to give any, at least for 2 months, I don't want to give any interviews. The reason was that I wanted to reflect upon my own career, because I believe that even if I had demitted the office, I am bound by certain constraints. But this is one thing, what happened in July 2006, I will have to seriously think and someday come very clean about it. I want to say something different. It happened, Mr. Thakkar gave the dates, I think dates were slightly wrong. It happened on Monday and Tuesday, last 2 days of the Chief Justice's tenure. What I want to tell today with great deal of emphasis is, immediately on the next day, eminent members of this bar led by late Rajni Iyer, they came to my chamber early in the morning and offered compliments. Rajni Iyer was followed by almost 25 to 30 distinguished members of this bar, and it happened immediately on the next day. So today is the time to pay gratitude to them. Then comes 2017, which Mr. Thakkar referred. It was a Thursday on which it happened. Friday, Saturday, Sunday were holidays. And again, that is something about which I will have to speak very openly and right after I reflect upon my career and decide. What is important is, I was told that Bombay Bar drafted the resolution on the same day on which this event happened, where some cases were transferred from my court to another court. And immediately on the next working day, which was Monday, resolution was passed by the Bombay Bar. These are the two things which I must personally thank every member of the Bombay Bar Association. For the benefit of young members of the Bombay Bar, I want to add something to this. I remember 1991, I was a junior lawyer. It is this bar who took initiative and passed a very strongly worded resolution against the 4 sitting judges of the Bombay High Court, expressing that there are doubts about their integrity. Then Appellate Side Bar followed, other associations followed. There was one more resolution a few years thereafter, where something was said about Chief Justice of this court. So therefore, at least from 1985 when I started practicing here, I can say that Bombay Bar Association has taken up these issues which normally no bar association would take up. And I must tell senior members of the bar that junior members of the bar must be informed about all these events, because this is the stand which is expected to be taken by the Bombay Bar Association. I have very fond memories of some of the cases which are argued by senior members of the Bombay Bar. One case which I will never forget was where the Maharashtra law enacted in 1995, which was brought into force in 2015, was challenged, which prohibited slaughter of cow and its progeny. All distinguished members of the original side bar argued that case, which went on for about 2 months before my bench, consisting of my esteemed friend and colleague Justice Suresh Gupte. And what is more important was, it was such a sensitive matter, all members of the Bombay Bar who appeared before me showed great deal of constraint. Second case which I remember was challenge to some of the recent amendments of the Bombay Municipal Corporation Act, where it provided for charging municipal taxes on capital value. It was phenomenally well argued matter. It again went on for days. And third one was, of course, petition filed by Mr. Abdi, and very forceful arguments came from distinguished members of this bar, which led to that judgment. I am going to speak about it. Since I am on that Mr. Abdi's judgment, I want to share my personal thoughts with you. I went to Karnataka, I saw beautiful infrastructure which is provided to the judiciary. As a Supreme Court judge, I had occasion to travel to various high courts. I went to Patna, I went to Ranchi, I went to Allahabad and Lucknow. What kind of infrastructure, fabulous infrastructure has been provided to the high courts in these states. You go and see the old building as well as new building of Patna High Court. Lucknow, of course, is purely luxury. And look at what is happening in Bombay. Of course, it's a heritage building. We all love this building. Where is the place for lawyers to sit? Where is the place for litigants to sit? Litigants squat on the streets. There are no facilities, modern facilities which are available. The judgment of 2018 said that till 30th September 2019, 25 or 30 acres of land, I forgot the details, should be allotted to Bombay High Court, and there is also an order that a separate plot should be assigned for construction of lawyers' chambers. There was injunction order restraining the government of Maharashtra from allotting a very prime plot in Bandra Kurla complex, and 30th September was the date fixed for reporting compliance. Unfortunately, that matter was never taken, and therefore government parted with that very important piece of land over which there was injunction. And today we are struggling. I am told only 5 or 6 acres of land has been handed over. Now this is something on which members of the bar will have to stand and say, why litigants and lawyers in Bombay High Court cannot be provided with better facilities. Bombay bar is such a historic bar today. See, so many members are standing here. There is not even a proper auditorium here for conducting such programs. So this is one area where bar associations will have to take up the issue. I had occasion to read 2017 report of the structural engineer. Structural audit was done of this building. I'll say only shortly that recommendation was there should not be any load on the top floor of this building. Load should be brought down. This is in 2017. Today, half of 2025 is over. So this is a matter of serious concern on which members of the bar will have to really apply their mind and take a stand. Personally, talking about my career, I always believed that judges have to be very strict. I always believed that judges should not permit long arguments unless it is absolutely necessary, considering the facts of the case. And therefore, I always believed that senior members of the bar must be disciplined, and I did that. As I said in the appellate side bar function, I personally believe that if you want to be really successful as a judge, and if you want to really abide by the oath which you have taken under the Constitution, there is no option but to offend people. Without that, you can't perform your duty fearlessly. Because if you have taken the oath, you have to do your job fearlessly. And therefore, Mr. Thakkar talked about third innings. After having worked in 3 constitutional courts for almost 22 years, I have taken a decision not to do anything which will involve adjudication. After occupying the highest office of a judge of the Supreme Court, I felt I should not do any adjudication work hereafter. Advising and consulting, that's a different thing. One more thing which I want to say about bar, especially Bombay bar. In my long tenure of 15 years and 8 months, especially when I was sitting single, my earliest I rose from the court was 6:30. Sometimes it went up to 7:30. And every member of the bar, without exception, cooperated. Even heading a division bench also, I used to extend my court time to 6:30 also sometimes. But every single member of the bar cooperated with me. For all these long years, I never heard any member of the bar telling me that look sir, it is already 5 o'clock, so grant me adjournment. No. So this compliment has to be given to both the bars, that are extreme cooperation and patience they showed when they appeared before me. When I stand here today, I have to say something about the present status of justice delivery system. As I said other day that for me the best law school was Bombay High Court. As a lawyer, as a judge. Why I say as a judge? I was purely a civil practitioner. Thanks to Chief Justice Bhandari, in 2005, before summer vacation, he called me and told me, he said that, Brother Oak, you have long tenure. So now from June, you have to do bail work. And that bail work will continue for 2 sessions. I was really taken aback. My mentor, Justice Ajit Shah, was also in the chamber. He was the senior most judge. He said, for you, there won't be any difficulty. Vacation of 4 weeks is intervening. So devote the entire vacation for reading the criminal law, which I did. And I must admire the foresight of Justice Bhandari. And thereafter, successive Chief Justices gave me criminal roster, quashing, then division bench, dealing with the appeals. And it was a great learning experience. I remember my second last sitting in Bombay High Court, I believe with Justice Gadkari heading a criminal division bench. I remember distinctly that at least in 10 cases where accused had undergone more than 12 years of sentence, we granted clean acquittal, not benefit of doubt. So my journey in Bombay High Court was a great education. The best education I had was as chairperson of the Maharashtra Legal Services Authority, when I made it a point to visit all central jails except Ortho Road Jail in Mumbai. And that was a great learning experience. Interacting with the prisoners was a great learning experience. And as luck would have it, I landed in Bangalore. I wanted to do criminal work, especially criminal appeals. I decided not to do it because it's not like Maharashtra where session judge also records evidence in English. It was only in Kannada. And I thought that sitting in first appellate court, I should not decide and appreciate evidence on the basis of translated version. And Supreme Court, I thought that I'll get opportunity to decide very important issues concerning civil law. But when I started presiding over the bench, it was PMLA, UAPA and all bail applications, plus IB code matters and tax matters. That was the assignment given to me. And I must thank my Chief Justices here who made me work on the criminal side against my wishes, and therefore I could do some work on the criminal side in the Supreme Court. Talking about the justice delivery system, I am not going to quote those figures of pendency in Bombay High Court, or for that matter all courts in Maharashtra which are available on public domain on the National Judicial Data Grid. I must say that situation is alarming for 2 reasons. One is sheer numbers, and second is, now today we have a scenario where in magistrate triable cases where 20 years back or 30 years back bail was granted for asking, people have to knock the doors of the Supreme Court. Only one example I am giving you. The other issue, talking about Bombay High Court, we have sanction strength of 92. I believe when Mohit Shah was the Chief Justice, only once we reached 74. And I don't think we have crossed that figure. I may be wrong, but I don't think we crossed 80. And look at the filing which is happening in Bombay High Court. Not only here in Mumbai. Are you aware that filing in Aurangabad bench is more than filing on the appellate side of the Bombay High Court, principal seat? And this kind of filing, we are struggling with the just strength of less than 70. How we are going to deal with this situation? Look at so many arbitration matters which are filed. There are 30 petitions under section 34, 37 appeals. So many appeals are pending. People are languishing in jail. Bail petitions are not reaching. Now we have to find out some solution to this. And I want to say something about the solution also. One reason why we are not able to fill in vacancies is about the uncertainty in the process of appointment of the judges. I am the one who always batted for transparency. Today we have practice of publishing Supreme Court collegium resolutions on the website, on the public domain. Today, the fact of the matter is that once that resolution is published, professional life of those whose names are mentioned in the resolution, those whose names are recommended, professional life gets affected. I have seen worse things happening in Karnataka where some of the recommendations of 2018 were not cleared for 1 year. And that is the uncertainty. Because of this uncertainty that the lawyers are not willing to accept judgeship. Fortunately, during the tenure of Chief Justice Khanna, now entire collegium documents are on public domain. And I am surprised to note that those who are criticizing collegium system, I am not saying that it is the best, but those who are criticizing collegium system, they have not commented upon what is put on the website. If you are not read it, please read it. At every possible stage, the government has say. When the names are sent by the Chief Justice of Bombay High Court, Collegium of Bombay High Court or any High Court, the Governor and the Chief Minister can offer their comments on the candidates. Then there is full-fledged IB inquiry. What kind of IB inquiry is held? That is also on the domain, public domain. We have put those forms on the public domain, very thorough IB inquiry. And with report of the IB inquiry and the comments of the Law Ministry and comments of central government, that the matter comes up before the Supreme Court Collegium. So there are filters, and please look at those formats which are there on the website. What kind of process takes place, what kind of thorough inquiry is made by IB. And then after collegium clears it, if you are going to take 9 months or 10 months, who will accept, who will say yes to the call given by the Chief Justice to accept judgeship? I always said that on public platforms. I had recommended one young and bright candidate at the age of 45 from Karnataka, and after 1 year he withdrew his consent because he found that appointment may not be cleared. And of course, the loss to the judiciary is now gained to the Supreme Court because he shifted his practice to the Supreme Court and is extremely successful. So this is one area on which associations like Bombay Bar Associations will have to take a stand, because unless we take a stand and ensure that after the collegium recommendations are made, the names are cleared within a short time, the Chief Justice of the Bombay High Court and the collegium members will find it difficult to convince the members of the bar. This is not true only about Bombay High Court. I am talking about all high courts. Of course, the grassroots level situation in many high courts, smaller high courts, is different. There perhaps still Chief Justices are able to persuade people to accept judgeship. But this is one area of concern about delay in judicial appointments. And therefore now see the scenario. I believe if I had done some work about what should be the possible just end, because you know there was a judgment of the Supreme Court of Justice Chandrachud in 2016 or 17, where a formula was laid down how to calculate the just end that was applicable to our district and trial judiciary. Now, even 92 judges are not good enough for Bombay High Court. Look into the kind of filing which takes place in Bombay High Court. And other issue which bar will have to address again, are we going to get rid of arrears only by creating one more bench? Perhaps Bombay High Court is the only High Court which has 3 benches. So even whether that is the solution to create one more bench, even that issue will have to be addressed by members of the Bombay Bar and all members of the bar. And ultimately, it so happens that it is not only judges but even lawyers get blamed for delay. Litigants go to the lawyers and complain about matters not reaching. So lawyers have to also face the brunt. So these are some of the institutional issues, namely having proper infrastructure for this historic High Court. Secondly, to have proper just strength in this court. And thirdly, we must ensure that those who give consent, their appointments are cleared within reasonable time. These are the few institutional issues which I think members of the bar must apply their mind and take some action. It is already 6 o'clock, I do not want to consume more time, but I will close by saying that after I demitted office, I realized that how important is the office of post of a judge. In fact, in SCORA function, Advocates on Record function, I said that somebody said in the function, I think secretary or treasurer said that now Justice Oak must be looking for freedom. I said no. The best freedom I had was as judge of the 3 constitutional courts. And therefore I said when I demitted office that I had tinge of sadness in my mind that I won't be able to do the judicial work. I thank Bombay Bar Association for felicitating me, and I thank all the members of the bar who are here in large numbers, and I am sure that younger members of the bar will continue glorious traditions of Bombay Bar of taking stand on all institutional issues. And that's the, not message I will say, that's the request which I want to convey to the younger members of the bar. I again thank everybody from my bottom of my heart. Thank you.
Thank you, Justice Oak, for that heartfelt message and that insightful speech. I'm sure all of us will take this into consideration. With this, we end today's function. Do join us for a cup of tea. Thank you very much.